Welcome back to the Wealth Builder podcast. My name's Nick Donato, and I'm a financial advisor at Guidance Financial. Not many people may have heard of a testamentary trust, but it's one of the most powerful estate planning tools available. But what is this tool? How can it be used? Why should you use one? Today, along with Sheredyn Legg and Stephen Fries from Novum Law Group, we're going to help you sift through the jargon and answer these questions. Thanks for joining me again today, Sheridan and Stephen. It's good to have you back on.
Thank you very much for having us back, Nick.
Yeah, glad to be here again. Thank you.
And as we said in our estate planning basics, when we got to the will section, today we're chatting about testamentary trusts, and there's a truckload of information and jargon available everywhere around testamentary trusts. So I guess today we're here to help simplify that in a sense and help people understand what they are. So I guess simply put, what's a testamentary trust?
Well, in its most basic explanation, a testamentary trust is really referring to any type of trust that is created under a will. And it's something that only comes into existence once the will maker has passed away. So in some ways, it's very, very similar to a family discretionary trust that you've spoken out on your previous episodes. But the key difference is that they're triggered only on death rather than during someone's lifetime. And when you hear the word testamentary trust, you're probably thinking of the discretionary kind, but there are actually four main types that we deal with in estate planning. The first one being the life interest. So this is really a temporary arrangement that sets up a trust that operates inside the estate instead of being a separate legal entity, where a portion of the estate, whether that's cash or property, is set aside for someone to use during their lifetime. That might be where a surviving spouse might receive income for that can be invested for life, or they might be able to live in a family home or rent it out. And then once that person then pass away or the life interest otherwise ends, the remaining property or funds would then pass to the ultimate beneficiaries. So usually the children of the deceased. And these life interest trusts can be really, really useful in second marriages. The next type that you might think of is special disability trusts. So these are a form of government recognized trust that are designed to support someone with a severe disability, mainly to help cover their care and accommodation costs while also protecting their Centrelink benefits. So the assets in these trusts up to a limit won't count towards that person's mean tested income. So they'll receive their full government entitlements as well as having the trust assets available for them.
So if your child has a disability of some sort, is this the type of thing that you'd be looking at to help them out with?
Yeah, absolutely. And look, there's particular criteria. They have to be able to, not able to work more than a particular number of hours a week, et cetera, et cetera. So there's some eligibility criteria, but it can be very, very helpful because as Sheridan said, it basically means a significant chunk of money or a property for them to live in or whatever it may be is shielded from the means testing later. So it can be set up during a person's lifetime. As you say, if you've got a child who has a disability, you could set this up during your lifetime. But you can also give directions in your will that if a person is eligible to have a special disability trust, one can be established for them after you pass away.
Is it for just adults or do minors play a part if they need one?
I mean, really, it can apply to any age. Um, Obviously, you'd have to have adults who are managing it for the person with a disability. But no, it can be relevant for any person who has a significantly or a sufficiently serious disability.
Mm. And I think that rolls us neatly into the third type of trust, which is a protective trust. This is a more flexible option for someone who needs financial protection or management, but they don't necessarily meet the criteria of a special disability trust. So, uh, where people are vulnerable, whether they're struggling with addiction or substance issues, or they're just really not great with money, or are otherwise, potentially under the influence of someone that you don't trust, you might want to put their money instead into a protective trust for their benefits so that it can be managed responsibly by somebody else, but for that person's benefit.
So I guess in a domestic abuse scenario or an abuse scenario, not fun to chat about, but that's something that you would look at for someone potentially in one of those types of scenarios.
It's certainly one option. You can look at a protective trust, and another option is also just your standard discretionary testamentary trust, which is that last, the fourth, the last in the categories, which is also another option and would also see those assets being managed for a beneficiary, but not necessarily in their control. If they are going through those kind of abuses or a separation, that might also be another option for them. Um, yeah, so these are the ones that the discretionary trusts are the ones that are the most common, and they're the ones that are most similar to the, standard family trusts that one might set up during their lifetime. But the key difference being they are contained in somebody's will and they only come into existence after that person's passed away. So in that scenario, instead of assets passing directly into your beneficiaries' bank accounts, they would instead be placed into a trust, which then allows for a range of benefits and flexibility that you wouldn't have otherwise.
Yeah, and in today's episode, we'll just be focusing mainly on the discretionary trust side of things. Um, how do they work though? So in the family trusts, you've got all of those different roles with from the trustees to the beneficiaries and whatnot. How does it work in a testamentary trust or a discretionary trust?
Essentially, the roles in a testamentary trust are very similar to in a standard discretionary trust. You again have your trustee who manages the day-to-day decisions and decides, for example, how assets should be invested. And look, we always advise people, if they are the trustee of a testamentary trust, get some professional advice about this because it is big decisions, often about significant sums of money, that they are better to speak to a financial advisor, such as yourself, Nick, rather than just either put it in a bank account where it's not getting interest or just stick it in a term deposit where hopefully it beats inflation, but maybe not by much. Um, but so the trustee makes those day-to-day decisions, makes decisions about who gets distributions. The beneficiaries, similarly again to a normal discretionary trust, you'll have usually one primary beneficiary, and then that's the beneficiary who is receiving the inheritance. And then it'll be their family, their spouse, kids, etc., out from there. And then the two last roles you usually see are appointor. And so again, that would normally be who the beneficiary whose trust it is, because the appointor has the ability to remove or replace the trustee. So if the trustee is dealing with the assets in a way the appointor does not like, the appointor can just say, thank you, you are out. I'm appointing myself or someone else as trustee now. And then finally, the guardian, um, not in the sense that we've discussed guardians in the prior episode, but the guardian in this case is basically someone who is involved in the testamentary trust, but only has the power of veto. And that can be relevant. We'll talk about it later. In some circumstances, your trustee or your beneficiary is removed from control for their own protection, but you may want them to still have the ability to say, actually, I'm going to veto that decision. And so that applies usually for decisions like dealing with the capital of the trust. So if the trustee says, look, I'm not only just dealing with the income this year, I'm also going to distribute all the capital to whoever, maybe myself. The guardian has the ability to say, actually, no, you're not allowed to deal with the capital in that way. So, appointor, trustee, beneficiaries, guardian. That's sort of the four key roles.
And all of them are nominated via your will. So when you're writing down your will, you've got a list of these four people and who they are and what they do.
Essentially, yes. And often one person holds multiple roles there because, if it's, say it's your testamentary trust holding your inheritance, Nick, well, you probably want to be in control, at least initially. But by splitting those roles into those different categories, it means, say you are having some legal issues, then you can be hands off, and that comes to what we'll talk about later with the legal protection it can give. But you could still hold the guardian role, but either you or the will can specify who holds the other roles. So yes, there's flexibility and you can put it in your will.
But at the end of the day, I'm not the one making. If I do get an inheritance, I'm not the one making the will. So it's up to the will maker or
Correct.
inheritance, my parents, to decide who it does what role. And in some instances, the beneficiary might not be the best person to be the decision maker, so to speak, and then you can nominate someone else. Is that
Yeah, definitely. And that forms a big part of our discussion when we're actually sitting down to create one of these trusts is to understand everybody's dynamics and strengths and whether or not somebody is actually going to be an appropriate person to be in these roles. So we do start with a big explanation of all the roles and making sure that people understand what that is before we go and create what the structure of a testamentary trust is going to look like. And to I tend to use an analogy that I find makes it stick a little bit clearer in people's heads is the punch bowl or bucket analogy. So you would imagine a party where the trust itself is the punch bowl, and the person holding the ladle is the one who's deciding who gets served and how much. That is the trustee. So they're the one that's ultimately managing and dishing things out to people, whereas the guests are the ones that are waiting with their cups, and they are the ones that are potential beneficiaries. If you've got a trust set up for a specific person, it centers around them, they might just be the guest of honor. They might get a little bit more, but it's ultimately up to the ladle holder about how much they do get. And then you've got the host that you can liken to the role of the appointer. So they aren't directly responsible for doing the work and dishing drinks out, but they can swap out the ladle holder if they're not quite happy with how things are going or who's getting served. And then finally, there's the security at the door, who's like the guardian, and they're essentially just keeping an eye out on everything. And if someone wants a particularly big or like a capital distribution, they're the ones that have to sign off on it. So it's all about providing those checks and balances and making sure that you're putting people into those roles who are going to do it well. And that's yeah, definitely quite a lengthy discussion with the testator or will maker.
so let's be real. Sounds like there's a lot of people involved, or there could be a lot of people involved. So at the end of the day, is what's to add, I guess, this bit of complexity, what's the benefits of even having a trust to begin with, or having this testamentary trust to begin with?
Sure. So, I mean, asset protection is one of the big pluses. So, you're right. There can be a lot of people involved. Usually, say I inherit and it's my testamentary trust. Usually, I'll be the one holding the ladle, and I'll probably also be the host who can put someone else to hold the ladle, and I'll probably also be the guardian, security at the door, and I'll also be a beneficiary. But if say it's my parents, if my parents, when they were making their wills, had spoken to someone like us, then the testamentary trust provisions in that will say, okay, if Stephen goes through a divorce or goes bankrupt or is in one of those situations where his assets are at risk, then take him out of control, remove him from direct control of the trust, leave him still with the guardian role so that he can say, yeah, actually, no, stop, don't pay the capital to someone else. but take him out of the roles that actually allow him to directly initiate things. Because then, if I go bankrupt and a trustee in bankruptcy is put in, it means they can't just step into my shoes as trustee or appointor, as the case may be, and say, okay, we're going to distribute all the assets from the trust to Stephen personally. Stephen is bankrupt, and therefore those assets go to the people to whom he owes money. If I'm not sitting in those roles, they can't step into my shoes, so to speak. And similarly, look, from a family law perspective, it's not bulletproof, but what it does do is, again, if I'm going through divorce, my lawyers can say, well, Stephen doesn't control that testamentary trust. It's still something that the court would typically at least factor in and say, well, sure, maybe he doesn't control it, but it's definitely something he's going to benefit from. So we'll put it aside, maybe. Maybe we won't carve it up. The other marital assets, well, we're going to nudge a bit more to the wife because Stephen has that to fall back on. But usually, again, it's not bulletproof, but usually there's a higher likelihood that the inheritance itself won't be carved up because it is in that separate legal structure. It's very easily defined and identified as being a contribution entirely from my side of things. And technically, I don't control it. So there are those asset protection things where we have those automatic clauses built in that temporarily remove someone if they're going through one of those risky situations.
So I've got two kids, 18 months and 4-year-olds. It's hard to think about them getting married and whatnot, being so young. But hypothetically, when they are older, if they were in a relationship, and obviously you don't wish this upon anyone, but if they were in a relationship that we thought could go sour and the secondary partner involved wasn't too desirable in our mind, would something like this then potentially be set up for when I'm not here to protect them?
Yeah, I mean, I think exactly. It's part of the flexibility that you have in saying, okay, if these circumstances happen, then I want someone else to be in control for their protection. And again, we can tailor it to a person's specific circumstances, but that is really the big plus. Asset protection, and I suppose alongside that, tax efficiency, um, which,
Mm.
as an investment advisor is probably near and dear to your heart. Um, but say I get an inheritance of $1 million. Um, I can choose to just inherit it, or I can put it into testamentary trust, and from there, if it's generating income, I can distribute to minors, and they would actually be taxed as if they were adults. So they get the 18,200 tax-free income and so on through the tax brackets. So that can be quite handy in spreading the load tax-wise.
Sure. And just to show that in practice, so let's say that a parent leaves, say, $500,000 to their child. If that goes straight to the child into their own bank account, they'll invest it, they'll earn income, and then on that income, they'll pay tax at their own marginal rate. So if they're a working adult, that could be anywhere from 30 to 45%. And then after they've paid tax, they might then use that after tax money to pay for their own child's school fees or activities. But if that same $500,000 was invested instead inside a testamentary trust, in that case, the trustee could then direct some of the income generated straight to the minor children. And since minors are treated as adults for these types of trusts, not ordinary family trusts, but discretionary trusts, each minor child can receive up to the tax-free threshold, so $18,200 or whatever it is now, tax-free. So it means that thousands of dollars every year are going directly to the children, directly to these kinds of school fees, books, activities, and expenses instead of to the tax office.
That's always good, being able to save on a bit of tax. And the other thing with those types of or these types of trusts, any types of trusts, you can also invest them in any way you want, whether that's in shares or property or manage funds, whatever way you think is appropriate for the beneficiaries to potentially grow their funds or to receive their inheritance. We can You can invest it again
Mm.
through professional assistance or as the trustee on your own. With these types of trusts as well, in a regular family trust, we have to distribute all of the income that's earned. Within a testamentary trust, do we have to do that?
So the tax rules are very similar in that regard, in that if you don't distribute in any given year, then you may be taxed at the maximum rate. But I guess the advantage of the testamentary trust is, as Sharon was saying, you've got multiple people, in addition to just yourself and your partner, for example, you've got potentially multiple kids who also can be very tax advantaged in receiving income. So, yeah.
And I think that kind of touches on another advantage that's, often underrated with testamentary trust is just the sheer flexibility. So as you were saying, Nick, there's a lot of flexibility about what you actually invest in that testamentary trust. Um, you also have got flexibility from the testator's point of view because they've got the full ability to dictate the terms of the trust. So how much goes into it, who's in charge, who can benefit. Depending on how the will is written, the setup might take the form of an all-in-one trust or multiple trusts, each for individual beneficiaries. So let's say I set up the Sheredyn trust. So when I pass away, a single discretionary trust through my will is set up that can be then used to support all of my family, including my children, grandchildren, my spouse. It's very flexible and simple that way, and everything is managed under one umbrella. But let's say I have three children that I want to make sure benefit equally. Well, then the testator's got the flexibility to then decide, well, actually, I want to create three separate trusts for each one of my children. And that way, each of them can manage their own trust and take on the key roles and responsibilities. So, in our punch bowl analogy, they would each be holding their own ladle and have their own punch bowl and hosting their own party. So, there's quite a lot of flexibility there in how the testator sets it up. And yes, as we've touched on, there's obviously flexibility in what you invest and flexibility for beneficiaries. Depending on how it's been set up, they might be able to decide whether to take their inheritance directly or to put all or some of it into a testamentary trust. So you can make it optional. For example, if somebody inherits 800,000, they could, if they wanted to, decide, well, I'll take 300,000 of that and just pay down my mortgage because then it's fully paid off. And then the rest of it, the other $500,000, well, then they can place that into a trust, which can then be invested and used in the most tax efficient way possible for the family.
And on flexibility, I don't want to kill myself off too soon, but if I pass and when my children turn 18, I don't want them to go out and buy themselves a nice car, nice Mustang with my nest egg that I've tried to build for them to help them live their life. So is there any restrictions? Like maybe I don't want them to get it until 25 or something like that. Any restrictions I can put on the trust to limit amounts
There,
drawn?
there definitely are. There are a couple of ways that you can do this, but the main one that we do is say that, all right, everything will get tipped into a testamentary trust as soon as I've passed away. But my child can't take any of those controlling roles. They can't be the trustee, they can't be the appointer until they have reached a certain age. We call it the preservation age, but it's whatever age you set there. So it might not be 18 these days. We're looking more at, 21, 23, or 25. So generally when people have got a little bit more of a sense of what life is, money being, doesn't just grow on trees. So it's we're seeing it get later and later and waiting until people have had the opportunity to go to uni or set themselves up with a job and get a little bit of a taste of the real world.
Gotcha. So there's, I guess there's so many benefits, it sounds like, to these testamentary trusts. Why doesn't everyone put one in their will?
It's a good question. I think one of the biggest reasons is just a lack of awareness. Most people don't even know these trusts exist, or they assume that a simple will enough would be enough to cover everything or their circumstances. So it's sometimes it's not that they've made a conscious decision to avoid it. It's just simply that they've never been told about it as an option, or they haven't had a chance to fully understand the benefits. And I think there's a bit of a misunderstanding around what these trusts actually do as well. And then of course you've got the cost considerations because they can be more complex for sure. They do take more time and effort to set up compared to a basic will. There's a lot more paperwork, there's more decisions to be made, and usually it does involve a lot more upfront legal advice. So for some families, it can feel like a bit much, especially if they're not sure if it's worth it. And then for costs, yeah, there are, additional costs. They are more expensive than creating just a simple will, because as Steve mentioned, it contains the entire trust deed, so it's a much bigger document and a lot more bespoke and tailored. But what you don't have is the ongoing compliance costs that you would have with a family trust. So if you set up a family trust during a lifetime, you've got those annual compliance costs, not only the establishment costs, but with testamentary trusts, you've just got the cost of preparing the will, and it basically just sits there. You don't have to pay anything. It's only later when the trust comes into existence on death, or if a beneficiary chooses to use it, that's when it's created. And then, yes, you've got those ongoing costs. So,
Mm.
yeah.
And I guess alongside that, there are sometimes circumstances where it just doesn't particularly make sense for someone to have a testamentary trust. For example, if a client comes in and they've got a comparatively modest estate and they say, well, look, my kids are basically just going to get their inheritance and pay down their mortgage. And that is what is going to happen to it. There won't be any leftover. I don't think they're headed for a divorce. They're not in a high risk profession. There's no particular asset protection requirements. Then we'd be saying to them, well, we could include the testamentary trust provisions, but at the end of the day, it doesn't sound like your kids are going to need to actually use them because they're just going to pay down the mortgage. So there are circumstances like that where it just doesn't particularly bring much advantage. And I guess the other part around it is sometimes when we are meeting with clients, they have difficulty actually identifying who would be the right people to put in control of these testamentary trusts. And because it is, a big decision. And the ideal is if you can just say, well, this is Sheredyn's trust, she's in control. But where people can't do that, sometimes they say, well, actually, there's no one around who I'm really confident would be right to manage these if we set them up. So we'll just keep it simple. We'll just give everybody their own share, and it's on them from there what happens. And look, there are options there, professional trustees and various things, but that is one of the reasons sometimes why people don't go down that route.
So in some instances, their estate might be simple and not require it to gain these benefits, and then I guess that leads into who would benefit from the use of a testamentary trust the most. And from our correct me if I'm wrong, as the experts in the field, but from my understandings and from this conversation, it'd be those who are in vulnerable situations, if that they run a risky business and bankruptcy is a issue, if they're in a relationship that may go sour, or if they have a disability of sorts.
It is definitely very, very beneficial for vulnerable beneficiaries. And you're right, whether or not that's addiction or money issues or influenced by others, a testamentary trust is a good option that allows you to support them without handing over everything at once, and it just basically provides structure, protection, and peace of mind. And look, even if your beneficiaries are responsible and they aren't at risk or in a high risk career, you still might want to use this trust just to protect against external risk like relationship breakdowns or creditors, bankruptcy, or legal claims. So it's about keeping your hard-earned money safe and making sure that your wishes are carried out. And otherwise, yeah, you would be looking at it. One of the biggest triggers for us to start considering whether or not testamentary trusts are a good option, in addition to what the stated beneficiaries are like, but if it's a high value estate. So if you're leaving behind a significant amount of assets, a testamentary trust can really help protect them, manage tax a lot more efficiently, and give your beneficiaries long-term flexibility that you wouldn't otherwise have with a simple will.
Thanks for adding that in there, Sheridan. Do either of you have any last thoughts or anything you want to leave the audience with around testamentary trusts?
Well, I think just that they are quite a useful and flexible tool. They're not going to be relevant for everyone, but for people who have significant assets or beneficiaries with, you know, difficult circumstances, it's definitely at least worth having a conversation about because they are very flexible. They can really be tailored to meet the needs of the will maker and the beneficiaries. And they're not for everyone, but where the circumstances demand it, they can make a massive difference.
Mm. Especially if you make them optional, they're not locked in. It's just an in case. So when you pass away, your beneficiaries can go and speak with someone like Unique or an accountant and get a little bit of an idea about whether or not they benefit from a testamentary trust. And you know what? At least the option is already there, because it is one thing that you can't add in later. If your will is a simple will, you can't make it a testamentary trust later. It's your beneficiaries lose out in that case.
Well, that's a wrap for today's episode of the Wealth Builder podcast. Thanks to Sheridan and Stephen for joining me today. If you wanted to have a further discussion about testamentary trusts, if they're right for you specifically, you can find them at Novum Law Group. Thanks to everyone for listening in today as well. If you've liked the episode, feel free to drop us a message or share it with someone you know who might benefit from our conversation today. If you wanted to discuss this topic or any other topics you've heard on the Wealth Builder podcast so far, feel free to book in some time via the guidance website or the link in the description. I look forward to bringing you the next episode in a fortnight's time. But until then, have a great day.
The information in this podcast is of a general nature only. It does not take into account your personal objectives, financial situation, or needs. You should consider whether the information is appropriate for you and, if necessary, seek personal financial advice from a licensed financial advisor. Past performance is not a reliable indicator of future results. All views expressed are those of the presenter and should not be relied upon as a substitute for professional advice.